irrelevant for this reason. We're not dealing here with the opening of new accounts. We're dealing with the operation of the existing accounts. And we know continued for a full year after that. At least, in fact, in excess of a full year after that.
Yeah.
Which takes us to the 9th and 10th of September 2016. And just to give context, earlier I said to your Lordship 18 months, that goes from the 15th of December 2015 when they identified the applicants as posing high risk. The 10-month period is what I'm going to deal with now. So on the 9th and 10th of December, there's email correspondence between the CEO of Bob and the corporate office in India on exiting the relationship. On the 16th of September, there's the letter to the South African office confirming the instruction to exit. Now that's 16 September 2016, and that's more than 10 months before the notices of termination are given. So even though on their version they decide they're going to exit this relationship, they do nothing for 10 months to terminate those accounts. And your Lordship can then skip to the last page 5 of 5, where the decision on 1 July is taken by Bob to terminate the applicant's accounts. That ties in with what I said to you, which was roughly 10 months from September 2016, and then the termination notices of that. My Lord, if I can then, in the limited time available, just highlight certain aspects of these heads of argument.
Yes.
And if I can take you to paragraph 30 of the heads. My Lord, what is set out under section B is all quite important to me, but your Lordship has some of those facts and your Lordship will read all of that at your Lordship's leisure. In paragraph 30, such as you have, my Lord. When your Lordship is not burdened with hearing my voice.
No, there are many voices that I hear. In court.
My Lord, if I can take you then to paragraph 30, the first point we've made, that we want to make a further point, we submit the court is not called upon to determine the merits of the interdict under Part A for two reasons. First, to do so would effectively reserve the function of the court, which is to determine the matter by way of special allocation later in the year. But secondly, the requirements of the present interim interdict, precluding Bob from closing the accounts, turn primarily on the right of access. Then we say, in addition to this, the directive of the DJP is that Part A is to be heard in December, and the present hearing is merely to determine what should happen pending the determination of Part A in accordance with the directive and the timetable for the exchange of further affidavits. The applicants have not dealt with the issues relevant to Part A in any reply affidavit, as such a reply will only be delivered once Bob supplements its current answer. And the Lord is necessary. They say that the affidavit that they delivered is an affidavit merely for the interim relief. Now, it's clear that they intend putting up further evidence in relation to Part B, but it also, my Lord, goes to the point that apart from the difficulties that the court had in relation to the allocation of the matter, the respondent itself, by its own conduct, frustrated any hearing that could conceivably have taken place on the 15th. By the 15th, when the matter was to be heard, there was no affidavit before court, and when they ultimately put up an affidavit, they say it's not their full affidavit. Having taken, we can count on how long, but probably almost a month to do so. Under the test applicable, my Lord, we've had some of these discussions, but I want to highlight some of the case law. In paragraph 33, we say it should be kept in mind that the Constitutional Court is enjoined courts when considering whether or not to grant an interim interdict to do so in a way that promotes the object, spirit, and purpose of the Constitution. That's the OTA decision. And in paragraph 34, we say, in considering an application of the present nature for interim relief, the focus of the court should rest on the fact that Bob will suffer no demonstrable prejudice if the relief is granted. This is partly evident from the fact that Bob imposed 3 arbitrary and unreasonable deadlines, one after the other, each deadline voluntarily extending the previous one. So your Lordship will recall, and it's set out in earlier sections of the heads, and initially they gave 6 days notice of termination, and then it was extended to 19 days, and then they extended it in the middle of August to the end of September. So they have no difficulty. The last extension, a period of 6 weeks, and then the court asks, well, if you're prepared to have granted 3 extensions unilaterally, the last one for 6 weeks, how much demonstrable prejudice can there be in the next 2 months and a week before the hearing in December? In paragraph, in section D, my Lord, we say the requirements for the interim interdict are clearly all met. We say in paragraph 36, this requires first and foremost a consideration of what the requirements are for interim relief of the kind sought here, because there is a difference, and whether those requirements have been met. In turn, and at most, this may require a very brief assessment of the applicant's prospects of success under Part A, and that's where we make the point that what your Lordship essentially looks at is whether there's a triable issue. And the reason we say that is because of the wording of Section 34. Your Lordship simply has to be convinced that there is in fact a dispute between the parties. And elsewhere in these heads we highlight the dispute. Lord, in the sections that follow, we set out Section 34, paragraph 39 and 40 I've dealt with earlier in my submissions to your Lordship. And if I can then, my Lord, it's always enjoyable to quote a case against an opponent which has appeared in, but all the more so when he is set in judgment and he's the judge who's decided the matter, as we do in paragraph 41, where our learned friend Mr. Marcus, sitting in the Labour Appeal Court, had the following to say. In my view, access to the courts of law is foundational to the stability of society. He then goes on to quote from the Tulane Law Review with approval in the passage that follows, and essentially further down in the quote at page 20, he says, whether the claim is well-founded or not is a totally different and indifferent fact. It goes to the point of on the merits of the ultimate dispute. You don't decide whether there's a good case or a prima facie case, but simply is there a bona fide dispute. Further on from our learned, your Lordship say he better explain. I hope he has to sing for his lunch as well. In paragraph 42, quoting further from the article, the point is made that at its core, the right to due process reflects a fundamental value in the American constitutional system, clearly also in ours. Perhaps no characteristic of an organized and cohesive society is more fundamental than its erection and enforcement of a system of rules and enabling parties to definitively settle their disputes. And then the court goes on at essentially level. It comes back to the issue of due process and the rule of law. In paragraph 43, we say it's right that the Section 34 right contained in the Constitution is a necessary corollary of the rule of law enshrined in Section 1C. This has further been interpreted by the Constitutional Court to mean that a person has a constitutional right to an effective remedy, which entails access to judicial as well as enforcement mechanisms that enable a person to protect his or her substantive rights. In Lord, we refer to quite a useful article by the chapter is by Brickell and Friedman. We give you a Lordship that reference, and we will also give you a reference to the Modicliffe decision, which I want to deal with on the next page. We point out that Brickell and Friedman note that where there is a cognizable cause of action, which is not limited to a cause of action founded on the specific rights contained in the Bill of Rights, Section 34 of the Constitution entitles persons not only to access to courts for the sake of access, but to meaningful access that leads ultimately to the enforcement of an effective remedy. So effective, it's not some notional right of access. It's not that you have access in December. It's not that you could have approached a court on a further urgent application, but can the court grant an effective remedy. And we say that position of Brickhill and Friedman, that one has got to look at meaningful access means whether the court can give an effective remedy supported by the Constitutional Court's judgment and monitor. Lord, of course, all of these cases have their own factual matrix, but the principle emerges from monitor.
I've read those, Mr. Baroda.
Thank you, Lord.
Is your time up yet or not?
Is your Lordship already tired of hearing my
I need
voice?
to be fair to your colleagues.
Lord, can I quickly go through and see if there's anything I want to deal with now and I'll approach finishing the argument. Paragraph 47 we do want to highlight because our learned friends make something of the point that there's no authority for this kind of relief. My Lord, clearly we're aware from practice that this is done. I can't point your Lordship to a reported decision, but your Lordship need look no further than the case of Fossey versus the Minister of Safety and Security. The relevant quote is in paragraphs 47, where it says appropriate relief will in essence be relief that is required to protect and enforce the Constitution. And further down, if it is right enshrined in the Constitution, if it is necessary to do so, the courts may even have to fashion new remedy to secure the protection and enforcement of these all-important rights. And we say this is exactly such a case, my Lord, where there has to be meaningful access. My Lord, we then deal with the requirements of Section 34, which I'm not going to detain your Lordship on. We say that it's a threshold that's easily met in this matter, my Lord, and we then set out, my Lord, at length the issues. Then we say in paragraph 83, in this case the applicants have a reasonable apprehension of irreparable harm if they don't secure an interim entity, preventing the closure. The issues they would have had determined and the part they will become entirely academic and irrelevant, and we demonstrate that. Lord, there's a section that deals with the balance of convenience from paragraph 95 onward, and we would simply ask your Lordship to highlight paragraphs 96, 97 and 98, with all of the sub-paragraphs, which I'm not going to take up time taking your Lordship through for the present moment. Lord, subject to just taking an instruction, we submit that's the argument in chief, and we ask you in order in terms of the draft. Your Lordship will see, we believe that we suggested a fair order in relation to costs that those be reserved for determination by the court hearing party. Your Lordship will be with me for a moment. As it pleases.
Thank you, Mr. Baroda. Mr. Daniel.
Thank you, my Lord.
Daniel.
My Lord, I made some notes about the debate between your Lordship and my learned friend, and I want to deal with some of the questions which your Lordship put to Mr. Bana, and I think it's prudent that I do that before I get into the narrow ambit of of the first to fourth applicants' specific circumstances that apply to this matter. My Lord, the first point is that one must remain mindful with respect, my Lord, of the distinction between the relief sought today and the relief which will be sought on the 7th and the 8th of December. The relief which we want today is a protection of the applicant's right to a fair trial. That's all that the applicants are asking for. And they ask for that under the auspices of Section 34 of the Constitution. We submit with respect, my Lord, that that right is, given the papers and the contents of the papers, is clearly established. It is not even a prima facie right at this point in time. And that being so, my Lord, your Lordship will be slow to consider the balance of convenience, because the stronger the right, the less attention you will give to the balance of convenience, and the less it comes into play. Our case is simple, my Lord. If we are not heard and we do not find redress now to find a way to protect the violation of our clients' rights pending the 7th and 8th of December. Our clients have effectively been denied through the legal process the right to put their case and the right to a fair hearing. That is the...
Let me just make a note of this.
Denied through the legal process the right to a fair hearing and?
Yes, ma'am.
The right to a fair hearing.
Yes, ma'am. A hearing in itself.
A hearing in itself.
On the 7th and 8th of December. Told that the horse is bolted, you can't ask for interdictory relief because the accounts have all been closed, is not a fair hearing when that result was achieved or obtained because the procedure in this court does not allow us to have that issue ventilated. Your Lordship asked my learned friend, Mr. Bana, why did we not, or is it possible to approach the court to get an in, as it were, if one knows that the date for your allocated date is too far off in the future? We had that. We were at court, my Lord, on the 17th of August to have the matter heard. The parties were ready to argue what we are arguing today. And we were told that the court could not accommodate us on that day and that this is the very next day that the interim relief could be accommodated. The application was originally brought, my Lord, on the understanding that Part A as such, the interim relief, would be heard by this court. But, my Lord, given the practice manual and given the procedure, one cannot enroll a matter in this court. And if your papers are going to exceed 500 in number, and if the matter is going to take beyond a certain time period, what one is...
It depends. Because sometimes applicants intentionally burden the papers with annexures so as to delay the case. So they go to the DJP and say, we've got more than 500 pages here, the case can't be heard this week. It depends on the context.
The point taken by His Lordship Mr. Justice Ledwaba when he entertained our request for a date, and it was also not the point taken by the respondent at any point in time. There is no suggestion of a loading of the record for any reason.
I'm not suggesting that, no. I'm just saying it depends on the facts, how you come to court, when you are heard and when not.
So we arrived in the hope file papers issued.
The same that I asked Mr. Bana, why, I just need to know why couldn't reply not have been filed since the mid-August?
That we deal with it to a certain extent in our supplementary heads of argument. But what my learned friend did not mention to your Lordship is that there is an outstanding issue of production of documents which has been called for. Your Lordship would have seen the file that was produced.
Yeah, I looked at that and
obviously I looked at the authorities. It's not there for the asking in motion proceedings.
Of course not.
I know you were told, when I say you, the applicants were told that some of the documents asked for did not arise from anything said in the answering affidavit. Some of the documents were already in your possession, and some of them are totally irrelevant in the context of the respondent's case, that it need not investigate the truth of all these suspicious transactions.
and the rises.
Would I, or the next court in December, or any other court, under those circumstances and given those facts, order production of documents in motion proceedings?
To the extent that the answer is the document is in your possession, that is not an excuse to make the document available. To answer that the document is in the public domain, fetch it yourself, is not an answer to a production of documents. The answer that it is relevant or irrelevant is not a conclusive answer anymore. And the court can interrogate that question, my Lord. And then there is also Rule 3514, which provides, and that's the strict rule, my Lord, where one won't simply get discovery in motion proceedings. But what we asked for was in terms of Rule 34.
Say, to my knowledge, that discovery and
motion proceedings is only ordered in exceptional cases.
Yes, under Rule 3514. Under Rule 35, discovery in the true sense of the word, it is production of the documents referred to in your affidavit. Now, we had to do that. They have also referred to documents in their response, which they say are there, which are patently not so. And we have raised, my Lord, by example in our supplementary heads of argument, not intending it to be a comprehensive, complete answer on the discovery, because that's surely not before your Lordship at the moment, but we have dealt with that issue in the supplementary heads of argument, and I'll urge your Lordship with respect to consider the argument advanced there related to discovery. But that was one aspect. There's also in the supplementary affidavit deposed to by the first to fourth applicant's attorney of record an expose of the exchanges which took place between the attorneys prior to the hearing of the matter for additional documents to be produced. And they were not readily forthcoming, everybody being aware of the fact that the matter must be entertained on an urgent basis, never being an objection to urgency in this matter. There was a dilatory attitude, if I may put it as high as that, on the part of the respondents to produce documents which were reasonably asked for in correspondence, so as to avoid the necessity of court applications and the filing of notices. And
relevant documents.
Excuse me, my Lord?
Relevant documents,
my Lord, which were ultimately produced, but not immediately when they were asked for. There was, for instance, a relatively simple request that the documents be delivered to the Attorney of Record's office by exchange of correspondence. Well, the response 2 days later was, well, the documents have been sent to your client, find it from them. It was that kind of attitude that frustrated, first of all, that required a necessity to file a supplementary affidavit, which has not yet been done because all the documents are still not in our client's possession, and there is an issue now about production of documents. There was also correspondence to the effect that the applicant was under the understanding that the respondent would want to file a supplementary answering affidavit. The respondent then came back in correspondence and indicated to the applicant, you indicated that you would file first a supplementary affidavit, in which event they would then amplify their answering affidavit. But my Lord, in the heat of the moment and in the throes of this matter being thrashed out as far as the time periods are concerned, etc., before His Lordship Mr. Justice Ledwaba, there was not time to file applications to compel documents. The applicants had 4 hours on the 16th of August to decide whether they were going to file a reply to approximately 500 pages of an answering affidavit. If one takes the annexures into consideration, and the annexures which your Lordship now asked my learned friend whether you can take cognizance of the contents of those documents, we say there's still a reply that has to come to that. We could not even properly consider the contents of the replying affidavit, answering affidavit, in the 5 hours that we were afforded. It was in the circumstances impossible.
Since then.
Excuse me, my Lord?
Since.
And so on the 17th of August, the matter was going to be argued on the founding and the answering papers.
Since then.
Since then, the issue of notice was filed. And a response has been received relatively late. Your Lordship has seen it. It's a file containing substantial documents just from the applicants, the first 4 applicants, and then also from the 5th to 20th applicants.
I remember receiving this
file relating to the request for documents on a Friday recently, Friday afternoon, and then I think on a Monday I was, much to my surprise, already given a file with an answer. Am I right on that?
I'm not entirely sure what the timing of that was.
But I mean, what I then thought to myself, will I now be confronted with an application that would order production? And then I wasn't.
Not now going to be confronted with such an application.
Well, at no stage, yes.
And we say that is not, all those documents are documents which ultimately are going to be relevant and will have to be interrogated properly when the 7th and the 8th of December arrives. But yes.
I wanted to ask you that, and I know we have limited time, so I don't want to spend unnecessarily time on this. But I do want to know why you say that these documents, without going through each and every one of them, I did look through that list, by the way, that weekend, and I think if I remember correctly, I would have granted the first one, but refused the others, with one possible exception. But be that as it may, what do you say the relevance of these documents will be for December?
Well, my Lord, the applicant's point of view, it was necessary for the bearing in mind, my Lord, that the respondent relies on the lawfulness of its conduct in terminating this contract. It did not, and has still not produced all the terms and all the documents relating to the contracts which they rely on, which grant them the alleged right to terminate the loan agreements. And that is one of the triable issues in this matter.
So not produce all the documents relating to
the agreements which relate to the first to fourth applicants, the loan and overdraft agreements, my Lord. And they will be relevant, my Lord. One doesn't know to what extent they will be relevant at this point in time, because we haven't interrogated them for purposes of this debate before your Lordship today.
What did the respondents say about that in the answer?
My Lord, but we challenge some of the responses which they've provided, which I refer to in the heads, my Lord, in the supplementary heads. We say some of their answers which they've given are inadequate. Paragraph 13 of the supplementary heads, my Lord, at page 9. In paragraph 13, it is stated that the applicants then on 22 August issued a notice in terms of Rule 3512. This is after a due process to get the documents under correspondence. So too did the 5th to 12th applicants. The deadline of 25 August stipulated in the first Rule 3512 notice came and went. It was not until 28 August that the bank responded. And then we say that that response is deficient. And we mention then examples, my Lord, in paragraphs 13.1 to 13.3.
What does the bank say about the contractual terms?
Contractual terms.
Well, they refer to certain contractual terms, but there are facility letters, the Annexure D, the reviews, which are relevant, which are to be incorporated in the loan agreements, which we say we are entitled to see. If you want to rely on an agreement, you have to produce the agreement. And we challenge that. We say that their response is inadequate. And we want an opportunity to deal with that. This is today is not the merits of the at stake and at issue is not the merit of the lawfulness of the termination of the facilities. But if we don't have access to those documents and are precluded from providing a comprehensive response by way of a reply, Your Lordship, if Your Lordship were to decide the matter today on the merits, you will not have afforded us, with respect, my Lord, a fair hearing, because it will be on incomplete evidence without a reply to allegations made in the answering affidavit. That is prejudicial, my Lord. So I come back to the submission at the outset, my Lord, that, oh yes, I've just received a note, my Lord, from my learned friends, Learner Junior. Yes.
Just stop it. And there are many examples. Let me just take one. The respondent says, with reference to the previous public protector report, that it raised numerous concerns and questions and so forth. Now that report speaks for itself, and they invited me to
Yes, they
read
can't
it
do that, my Lord.
in the answer. Now, what will you say in reply
my
to
Lord,
that?
with respect.
I mean, it speaks for itself.
I mean, it speaks
Yes,
for
my Lord.
itself.
What as one knows, my Lord, I think there's a judgment of His Lordship, Mr. Justice Southwood, about the manner in which one is supposed to refer to documents which you attach to an answering affidavit or to any affidavit. First of all, we don't know exactly what the respondents refer to in the public protector's report.
Well, they do give examples.
And those will have to be responded to at some point in time when Part A is properly ventilated and decided.
But just tell me,
I just wanted to know, what would you say in your reply to the allegation that the contents of the Public Protector's report concern the bank for a number of reasons? Now, what will you say in reply to the contents of the Public Protector report?
Firstly, my Lord, that report is under review. Yes, my Lord, and
What
I'm
part
not
of it
entirely
is
sure, my
under
Lord. I've got, I don't know. The fact of the matter is that is off the top of my head, my Lord. I have to submit that it is under review.
Only part of
Excuse
it.
me, my Lord.
Only part of it, to my
I can't
knowledge.
address your Lordship on exactly what part
Yes.
of it. Yes. But I can't take it further. There's more than one review, apparently, my Lord, and I'm not in a position to deal with it. To the extent that the Public Protector's report alludes to improper conduct, that can go to the goes nowhere as far as Bank of Baroda is concerned, because your Lordship is, as far as Bank of Baroda is concerned, confined by what they say in their papers about their reputation. So it's all very well to attach a report, but how does the report implicate or suggest that Bank of Baroda has suffered any prejudice? What Bank of Baroda does is that it attaches a document and says, this is what is said about somebody else. I appear for the first to fourth applicants. There's no iota of evidence before you, my Lord, of any prejudice caused by the first to fourth applicants, or any innuendo or suggestion that the first to fourth applicants have caused the Bank of Baroda any damage. So whatever they refer to in reports about what might transpire in the Oak Bay group or in the Sahara group does not assist your Lordship in coming to a finding that the Bank of Baroda is suffering reputational damage. And that's their case.
But the applicants
annex an annexure which sets out the interrelationship between all the applicants and who are the directors of each of these applicants and which shares they hold. And that's why it's been colloquially being referred to as the group.
I understand that, and that is as it is.
And they say the events of the last year or so concerning the group has caused us this reputational harm.
I must, with respect, ask your Lordship to find one paragraph of evidence in the answering affidavit of the extent or the nature of the alleged reputational damage. My Lord, if the gravamen of one's case, as it is the case of Bank of Baroda, is that I cannot maintain my business relationship with you because of the suffering, my reputation suffering, then one would want evidence of the existence of a reputation, and one would imagine then, if there was serious reputational risk, that the information exclusively within the knowledge of the bank, that it has lost clients. There is no word of evidence that a single client has terminated its relationship with Bank of Baroda, that it has lost employees who are not prepared to work for it. There is no single allegation of that in the papers. There is not a suggestion of the turnover. In fact, they complain that the turnover has increased. The amount of work that they get from the applicants has become impossible for them to deal with. That's just because they are either inefficient, my Lord, or that they are understaffed because of this. But that's not a ground, my Lord, that supports a suggestion that there is reputational damage. There is no evidence other than the generic reference to reputational damage. That's not good enough, my lord. We can't even respond to that. How does an applicant respond in a reply to an allegation that I have suffered reputational damage without particularity about that? When it was caused, and one must take that allegation then with a pinch of salt. When this application was launched, the first to fourth applicants were on terms that the loan facilities would be terminated on the 30th of September. And the other applicants, that's as far as the loan agreements are concerned. As far as the transactional accounts are concerned, the cut-off date was the 14th of August. The notice of termination was issued on the 7th of July. One would assume that all the reputational damage would then have already occurred. And then, my lord, at the drop of a hat, and without
or it could get worse in the next 3 months. Or the harm, the reputational harm could get worse.
Because they don't file their affidavit, they filed their affidavit the other day. They don't tell your lordship how the reputational harm has escalated. They don't tell your lordship since the filing of the notice on the 7th of July of termination that since our termination, look what has happened. What they do, my lord, is on the 14th of August, they agreed to extend the banking facilities to the 30th of September. Not only on the loan accounts, but also on the transactional banking side. Now, if they've suffered reputational damage and are so concerned about it, on what conceivable basis would the bank then extend, willy-nilly, just at the drop of a hat, extend it, when the pressure's on a little bit, to the 30th of September? That makes nonsense of their excuse, my lord, that from the 30th of September this year, they cannot again extend the banking facilities till the 7th of December. They've just done it. A month ago they were happy to do it, my lord, and there is no evidence before you that those circumstances can change. The only thing that they say will change is the volume of work. Now, my lord, as far as the first to fourth applicants are concerned, they have loan agreements, and their loan agreements dictate the terms of their engagement with one another. Clause 13.1.4, if I'm not mistaken, my lord, of for instance, it's Annexure 6. That series of annexures my lord, if you go to page 6, page 339, the heading is adjustment in cost of funding. What it says, my lord, is this is now this is Annexure 6.1. It's the loan facility agreement between the bank and the first applicant. What it says in clause 13.1.4 at page 340 is that if in the event that any other event occurs which is beyond the control of the bank, with the result that the cost to the bank and any other similar institutions registered in terms of the Banks Act of maintaining or funding lending is increased, whether directly or indirectly, then the applicable rate shall be increased by such margin as may be necessary to place the bank in the same financial position it would have been in if none of the events referred to above had occurred. So in terms of their agreement with my clients, they have already a mechanism in place to cater for the increased cost, whether it is a cost associated with reporting suspicious transactions, and I'll get to those suspicious transactions in a moment, my lord, whether it's the cost related to the reporting of that or the supervision of the accounts, if they have to employ additional staff, their salaries would surely have been, would be a direct or indirect cost contemplated in terms of clause 13.1.4. So that alleged prejudice which will arise now in the next few months, one doesn't know why it didn't arise between June and now, but will arise from the 30th of September to the 7th of December. But that prejudice is cured by the terms of their own contract. There's nothing stopping them from renegotiating the terms. They take these accounts on review whenever they want. To further demonstrate, my Lord, the nonsense argument of reputational damage, one must have a look, my Lord, at the situation in regard to the review of the account with annex, the first applicant. A review takes place on the 20th of May, and annex is granted a 6-month period from the 20th of May till the 20th of November. To wind up its affairs with the bank. 3 days later, on the 24th of May, annex is advised that they must terminate by the 30th of September. Now, my Lord, that does not demonstrate a careful consideration based on real facts in possession of the bank, which motivates it to terminate or protect its interests. Because nothing could have changed between the 20th and the 24th of May, and there is no evidence that anything did. So again, my Lord, the whole reputational issue, whether they refer to the report of the National Prosecuting Authority or any other report, has to translate into a direct impact on the reputation that Bank of Baroda had, which we don't know of, and which will suffer prejudice, which we don't know of.
The instruction from the CEO in India, what do I make of that?
When these new extensions are granted, he says terminate the relationship, and then the local bank says no, don't worry, we'll give you a bit more time. That demonstrates some arbitrariness, my Lord. One would have expected the local bank to report back to India and say we've received the request to extend the loan period until or to curtail it, and we sympathize with that because we are really suffering reputational damage. Well, there's no evidence to that effect, my Lord. You are asked in interim relief at this stage to delve into annexures to the answering affidavit to find out whether there is, on a balance of convenience basis, a reason to deny my client its indisputable right to a fair hearing to protect its interest. Its interest that it needs to protect today is to safeguard its right to the court to have a meaningful fair trial on the 7th of December, my Lord. And that's why we get back to the fact that your Lordship does not, for present purposes, have to go into the nitty-gritty of what's in the answering affidavit, and that your Lordship ought not to do that in any event, my Lord, because it is prejudicial to our client. Your Lordship asked my learned friend whether your Lordship has a discretion as far as Section 34 is concerned, or as far as the interim relief is concerned. Obviously, your Lordship, even if we tick all the boxes for interim relief, your Lordship does have a discretion, an overriding discretion which your Lordship will exercise judicially. Yeah. We say, my Lord, with respect, that there is not any evidence in the answering affidavit which could motivate your Lordship to depart from what the Constitution allows my client. In the specific circumstances of this matter, my Lord, you are confronted with a half-baked version on the part of the respondents that they will suffer reputational damage. And we say that that is not enough, my Lord, to unsettle the clear right to a fair hearing. My Lord, I touched on the issue that we came to court, my Lord, on the 17th of August, and this is about the access to court. We came to court on the 17th of August, hoping to have a hearing. My Lord, your Lordship raised the issue whether one could approach the court to ask for an accelerated date for a hearing if the allocated date by the registrar was too late. Well, we exercised that. We were invited by the acting Deputy Judge President to discuss the future of this matter, as one would do. If we arrived in the urgent court judge would have said, your papers are in excess of 500 pages, you must get a special allocation. That's exactly what we went to do. We got a special allocation. There was no other available date. We were given that assurance by His Lordship Mr. Justice Ledwaba. The parties, nobody took him to task about that and said, no, but there must be a way to come to court earlier. We were told in no uncertain terms, and Mr. Fine was present and Mr. Bana were present at that meeting, there was no doubt that we could not be entertained at any other time.
Except December.
Except in December. And that was on... Yes, I think there was a suggestion of a date at the end of November when the Respondents' Council were not available. 29 November or something like that, my Lord. But nothing turns on that week. Additional delay.
But that's for interstate, but that's what it's been saying for the next week. You have come to court, to the urgent court.
To the urgent court.
I'm sitting in the urgent court.
You know, I'm sitting in the urgent court next week, just for interstate. Could you have come next week and said this date in December causes us tremendous prejudice? We need an order this week.
Yes, my Lord, and then we would have...
Irrespective of what the DJP said. I'm not bound by what the DJP says.
Well, my Lord, the practice note says we cannot enroll a man. We would have had to file a practice note and said that this matter is more than 500 pages. It's going to take longer than the allocated 5 hours. We did that. We were sent to His Lordship Mr. Justice Ledwaba. Not to the presiding judge in the urgent court, but we were sent to His Lordship Mr. Justice Ledwaba. He took control of the matter. And it was a fact, an impossibility to hear us. Before then, we approached them.
The practice of this court doesn't allow you to approach
urgent court in
My Lord, we came to the urgent court.
apart from August.
After having been advised, my Lord, by His Lordship Mr. Justice Ledwaba, after full debate with all parties in chambers about how we would resolve this matter, and that is why we are here now.
I don't know whether that's at the court now, but just wondering, because no court is bound by a procedural ruling made by another court. One judge, for instance, could refer a matter for evidence. It then comes before the judge who's supposed to hear the evidence, and that judge will decide, I'm not going to hear evidence, I will decide this case on the papers. That can be done. So no judge is bound by a procedural ruling made by another judge.
We came to the urgent court for purposes of having our matter heard, and we were then told that you cannot be heard earlier. So the urgent court for that week, first of all, of course, the answering affidavit, we were then armed with had the benefit of an undertaking that endured until the 30th of September. So this is the first time that we have been able to come to court, but not on Part A, because Part A is agreed will go on the 7th and the 8th.
Yeah, I get the point.
Yes, my Lord. Thank you, my Lord. Your Lordship asked my learned friend about the test. How should Your Lordship now deal with interim relief? What? Yes, my Lord. We refer, Your Lordship, with respect to paragraph 9, my Lord, of our heads, our supplementary heads, and 8, where we deal with the judgment of His Lordship Mr. Justice Moseneki in the Constitutional Court, and we refer your Lordship in paragraph 8, I think it is, or 7, to the...
Let's look at the context of that judgment.
Context of that judgment, you know, there a complicated review application was pending.
Yes, he still said, I am not going to
Deal with the merits of that, yes. There is not intrude on that, but for a good reason, having regard to the facts of those cases.
If your Lordship decides the matter today,
Yeah.
on the basis of whether a prima facie case is disclosed, not in relation to access to court, but on the merits of the matter, then your Lordship has denied us the right. Then your Lordship, then the 7th and 8th falls away.
Yes, obviously.
But what is before you is not Part A. What before you is a right to have Part A fairly determined, my Lord. And that is significant. His Lordship, Mr. Justice Wilsoneki, tried to find a way and to deal with that, my Lord. And he said that it was not necessary for him to determine the cogency of the review, and second, by going no further than to describe the subject matter of the review for the restricted purpose of probing whether the High Court was right in granting the interim interdict. So we say that this is the closest analogy you're going to get, my Lord, about how you should approach what is coming. It is by no means a simple matter, not for me in any event, my Lord, about what's going to happen and what has to be argued on the 7th and 8th of December. It is made more complicated by the fact that all the evidence is not before you. My Lord, there's I have grappled with this. Yes, my Lord. Yes, but you must decide that relevant evidence once the supplementary affidavits have been filed, and once a reply has been filed, and a comprehensive answering affidavit, which we anticipate will still come once we file the supplementary affidavit. Once all of that is before your Lordship, you can't, with respect, my Lord, anticipate the relevance of the evidence that is to come.
Decided later as well,
Yes,
the
my Lord.
relevance.
That is when that court, you can't decide with respect now, my Lord. What is the relevance of an replying affidavit which is not before you? You simply don't know, my Lord. My Lord, I looked for yes, my Lord.
That's where it
That
goes,
is
the
my Lord,
case.
yes. My Lord, if I
Yeah.
might draw, we make a case that my first submission to your Lordship was we have practically a clear right to be heard under Section 34. But we also say that our application is not a frivolous or a spurious application. We have been denied a right will be denied a right to have our issue ventilated, my Lord, ultimately. In Fint Holdings, my Lord, I don't know whether it's in our trial bundle, versus the National Director of Public Prosecutions, and Zuma versus the National Director of Public Prosecutions. It's a 2009 Volume 1 report, my Lord, of the Constitutional Court at page 141. I just want to read your Lordship a passage at paragraph 62 of that judgment, where the court dealt with the question of right of access to courts. And it says, the right of access to courts exists to ensure that litigants who have suffered violation of their rights are not barred by procedural, legal, or other obstacles from obtaining just and equitable relief from the courts. And then it says, it is not intended to grant standing to a person even after that person has received full and proper hearing in a court of law simply because such person alleges a violation of his or her rights. So the principle is that if we are denied our right by procedural, legal, or other obstacles, then, my Lord, you don't just have a blanket right to court. That, the Constitutional Court says, that interpretation of Section 34 would essentially nullify the rules of standing in our law. It would create endless difficulties for the administration of justice. Now, we say to your Lordship, in that context, that the procedure which is effective in this court and that is applied in Johannesburg has effectively denied our client a right to have a full ventilation of the papers in the urgent court when the matter was originally contemplated it would be heard.
Yeah.
And
I'll make a note of it.
yes, my lord, and then what is there to decide, my lord, is not frivolous. We say that we have a triable issue, and your lordship will, if we don't have a hearing on the 7th and 8th, that triable issue, the right to have that tried will be denied. And we deal with that triable issue, my lord, in our heads. I'm not going to read it to your lordship. I'm getting a note that I've got 5 minutes left.
I've got the same note.
Yes, my lord. I say your lordship's time is up.
That is your case.
My lord, your lordship and my learned friend had a discussion about the pay agent.
Yes.
And I was
Deal with it after.
in reply, my lord.
I'll leave it up to you.
Well, I've got 5 minutes left, my lord. I've got to put that in the next 5 minutes. Sorry? Is it already over?
Yes, of course, your plans will go.
Oh, yes, I apologize, my lord. Then we have to,
Up is the
then I have to take the adjournment.
yes for now. We'll adjourn until
30:30. Yes, my lord. Thank you.
Just before you adjourn,
Yeah.
hesitate.
Yeah. Yeah. No, that's fine, Mr. That's fine. I don't care about lunch hours. Thank you, Court adjourns until 1:30.